I've handled a lot of cases over the years. Eviction disputes, contract fights, the occasional ugly probate matter that turns family members into strangers overnight. Most of them blur together after a while, the way work does when you've been doing it long enough. But there's one case that still comes back to me sometimes, usually late at night, usually when I'm thinking about something else entirely. It started with a knock that wasn't even a knock. It started with a piece of paper taped to a door. Her name was Henrietta Doyle. Everybody called her Hetty. She was 78 years old, and on a Tuesday morning in early spring, she walked out onto her porch in her robe to grab the newspaper and found an eviction notice taped to her front door. She told me later she had to read it 3 times before the words stopped rearranging themselves. $14,200 in back rent, 30 days to vacate. She'd lived in that house for 22 years and never once been late on a payment. Not when her husband died, not when her hip gave out and she had to choose between surgery and the electric bill. The signature at the bottom belonged to a man named Russell Pruitt, who she'd known since he was 9 years old, riding his bike up and down that same street, while his mother collected Hetty's rent in a coffee can on the kitchen counter, because that was just how Eleanor Pruitt liked to do business. Eleanor had been dead for 14 months by the time that notice went up. Hetty didn't call a lawyer right away. She called her niece, who called a coworker, who'd used me once for a fender-bender settlement, and told her I was decent and didn't talk to people like they were stupid. That's the only qualification Hetty cared about when she walked into my office a few days later, notice in hand, looking more confused than scared, which is usually the more dangerous of the two. I didn't start by asking about the notice. I asked her to tell me about the house. People think lawyers want the legal facts first, but I've learned the legal facts mean nothing until you understand what somebody's actually trying to hold on to. Hetty talked for 10 minutes about the kitchen she'd wallpapered herself back in 1987, about the maple tree she and Eleanor planted the same week she moved in, about how Eleanor used to bring over chicken soup whenever Hetty caught a cold. $340 a month, never raised in 22 years, paid in cash, dropped into that coffee can. No lease that either of them could put their hands on anymore. After Eleanor passed, Russell started coming around saying he was handling the rent collection for the family now. Hetty didn't think twice about it. Not until 4 months ago, when he told her the rent was going up to $1,100 a month and handed her a new lease to sign. She didn't sign it. She told him $340 was the rent his mother agreed to, and she intended to keep paying it until somebody gave her a real reason not to. She said he got awful short with her after that. I looked over the notice, then the complaint stapled behind it. Pruitt versus Doyle, filed in municipal court, eviction and damages calculated as if that $1,100 figure had been in effect retroactively for 4 months, plus some kind of market adjustment fee I'd genuinely never seen anybody try before. And then I asked her something I needed her to think carefully about. Did Eleanor ever mention a will? Did she ever say who the house was supposed to go to? Hetty said Eleanor mentioned once that it wasn't going to Russell outright, something about her church, but that was family business, she said, not something for me to worry about. I didn't tell her right then what I was already starting to suspect, that it wasn't family business at all, not if it was about to determine whether Russell Pruitt had any legal right to be standing in a courtroom in the first place. My paralegal, Priya Nair, pulled the probate filing the next afternoon. After fighting with the county's digital system for the better part of 2 hours, she set it on my desk without saying a word, which was her way of telling me to read it myself before she said anything, because she wanted to watch my face when I got to the part that mattered. Eleanor Pruitt's estate had been opened 9 months earlier. No executor had ever been formally appointed. No distribution of assets had occurred. The house on Maple Street, along with 2 other rental properties Eleanor had owned outright, still belonged, as a matter of law, to the estate, not to Russell. He'd been collecting rent on 3 properties that legally belonged to a dead woman's unprobated estate. There was more. There was a will, filed but never admitted. I guessed Russell was named executor. Priya told me I guessed wrong. The executor named in that will was Carol Pruitt Simmons, Eleanor's daughter, living out in Tucson. And as far as Priya could tell, nobody had told her that her brother had been suing tenants and pocketing rent checks under an estate she was legally in charge of. This had stopped being a simple rent dispute. This was a man with no title, no court-appointed authority, and possibly no inheritance at all, trying to evict a 78-year-old woman from a house he didn't own and had no legal standing to make decisions about. I told Priya to get me everything on that will and to find out why it had never been admitted to probate. Somebody was sitting on something. Russell's attorney was a man named Garrett Lowe, the kind of lawyer who'd built a whole practice on landlords and eviction filings, who walked into every meeting like he'd already won because most of his opponents folded before the second hearing. He hadn't dealt with me before. Across the table at the courthouse, he told me his client had been responsibly managing his late mother's properties for over a year, that Mrs. Doyle had been living below market rate out of his mother's charity for 2 decades, and that instead of accepting a fair adjustment, she'd simply stopped paying. I told him she'd offered to keep paying exactly what she and Eleanor had agreed on for 22 years, and his client had refused to take it unless she signed a lease tripling the amount. That's not non-payment. That's a landlord refusing rent he doesn't like the size of. He said his client was the owner, and the owner sets the terms. I asked him if that was actually true, and slid a copy of the probate docket across the table. The only person with legal authority over Eleanor Pruitt's estate, which still owned that house according to the county recorder, was a woman named Carol Pruitt Simmons. Had his client mentioned her? Lowe's face didn't move, but his eyes stayed on that document about half a second longer than they should have for a man who supposedly hadn't seen it before. He said the family was handling the estate privately. I told him there's no such thing as handling probate privately when real property's involved, and he knew that better than most. I told him I was filing a motion to dismiss for lack of standing, and that I intended to make sure Carol Pruitt Simmons got a copy of everything filed against my client in her mother's name. That was the first time I saw Garrett Lowe look like he wasn't sure he was going to win. Carol answered the phone on the second ring, and it took me about 2 minutes to realize she had no idea any of this was happening. Russell had told her he was just looking after things until probate cleared, made it sound simpler if he handled the rent collection himself so the houses didn't sit empty. She had no idea he'd raised anybody's rent, no idea he'd sued anybody. I asked her directly if she knew her mother's will named her as executor. There was a long pause. She said she knew there was a will, but Russell told her it had never been found. I told her it had been sitting in the probate court for 9 months, a public document, and I had a copy in front of me right then. The silence after that lasted long enough that I thought the call had dropped. He told me it hadn't been found, she said again, quieter the second time, and I understood she wasn't really talking to me anymore. She was doing the math on exactly what her brother had been doing for the better part of a year, while she trusted him to handle things. By the end of that call, she'd agreed to fly out for the hearing, and she'd agreed to file the petition to formally open probate and take her place as executor. I hadn't expected to solve a property dispute by accident, but that's often how it goes. You pull one thread looking for a defense, and the whole coat comes apart in your hands. It would have been a clean story if it ended there. It didn't. 2 weeks before the hearing, Lowe filed an amended response, this time built around a sworn declaration from Russell himself, claiming Eleanor had executed a second, more recent will 18 months before she died, one that left all 3 properties directly to him and superseded the will, naming Carol as executor. He said the document existed, but it had been destroyed in a basement flood at his house the previous spring, along with several boxes of his mother's personal papers. Convenient, Priya said when she read it. Maybe, I told her. Or maybe it was true, and we were about to spend 3 weeks chasing a will that genuinely didn't exist anymore. That's the kind of complication you can't simply argue your way around. A lost will, real or invented, buys exactly enough uncertainty to drag a case past the eviction hearing and into a much longer, much more expensive probate fight. The kind of fight that would exhaust a woman like Hetty's patience and her savings long before it exhausted Russell's. So I did the only thing left to do. I hired an investigator. Sam Ortiz had retired from the police department's fraud division about 11 years back, And he made a good living now doing the unglamorous legwork younger investigators didn't have the patience for. Title histories, insurance claims, the kind of paper trail most people forget exists. It took him 4 days to find what I needed. He told me Russell had filed a homeowner's insurance claim for water damage at his house 14 months earlier, itemized down to a water heater and a box of Christmas decorations, signed under penalty of perjury. No mention anywhere of boxes of his mother's personal papers, nothing about a will. The man had itemized a karaoke machine in that claim, Ortiz said, but somehow forgot a will. Either it never existed, or it existed, and he knew exactly where it was when he filed that claim, which meant it never went anywhere in any flood. There was a second thing buried in that folder: bank records, pulled through a subpoena Priya pushed through once Carol's executorship was pending, showing Russell had been depositing rent checks from all 3 properties into his personal checking account for 14 months straight. Not an estate account, not a trust account, his own account. Just under $61,000, about half of it already spent on a truck, a vacation, and a down payment on a boat. He wasn't just wrong about the lease. He'd been helping himself to his mother's estate for over a year. The judge assigned to the hearing was a woman named Eleanor Voss, no relation, who'd sat on that civil docket for 19 years and had a reputation for 2 things. She hated wasted courtroom time, and she had no patience for landlords who treated eviction proceedings like a formality. Before either side said a word about rent, she asked one simple question: who, today, holds legal title to that house on Maple Street? Lowe stood up and started talking about equitable interest under a subsequent will. Judge Voss cut him off before he got far, pointing out that this was a will no court had ever seen, supposedly destroyed in a flood, that, according to his own client's insurance claim, somehow spared a karaoke machine. Then she turned to me and asked to hear my motion. I told her the law wasn't complicated, even though my opposing counsel had worked hard to make it sound that way. The plaintiff in an eviction action has to actually be the landlord, the person with legal authority to enter into and enforce a lease. Title to that house rested with Eleanor Pruitt's estate, the only lawful executor under the only will ever admitted to probate in that county was Carol Pruitt Simmons, sitting right there in the courtroom, and she had never authorized this lawsuit, this rent increase, or this eviction. Russell had no lease with my client, no title, no court order putting him in charge of anything. What he had, according to his own bank records, was 1.5 years of collecting and spending money that was never legally his. Lowe tried to object to the relevance of the bank records. She overruled him before he finished the sentence. Then she turned to Russell directly, and the whole room went still. She told him she'd read the investigator's report and his insurance claim, and she wanted him to think very carefully before he answered her question under oath. Did he, or did he not, know the location and contents of his mother's supposedly lost will at any point in the past 14 months? He looked at his lawyer. His lawyer looked at the table. He said he knew where some of her papers were. She told him that wasn't what she'd asked. The silence after that lasted 11 seconds. I counted, because I always count, and silence in front of a judge almost always means something's about to break. Yes, he finally said. I knew where it was. Judge Voss dismissed the case without prejudice, ruling that Russell had no legal authority whatsoever to bring an eviction action or change the terms of that tenancy. She referred the whole question of the supposed second will and whether he'd concealed or destroyed estate property straight to probate court, where Carol's petition was already sitting. It wasn't a complete win, and I want to be honest about that, because too many of these stories pretend every case ends clean. Hetty got to stay in her home, for now, but that house still legally belonged to an unsettled estate, and what happened to her rent down the line depended entirely on what came out of probate. She asked me afterward, quietly, if she might still lose the house someday. I told her she might face a rent increase if the estate settled and a new owner had the right to ask for one, but nobody could simply take it from her the way Russell tried to. Not without a court appointing somebody with real authority, not without due process, proper notice, an actual lease, an actual legal basis. What happened to her wasn't legal. It just hadn't been stopped yet. She said Eleanor would have been furious with him. I told her I imagined she would have been. 3 weeks later, the probate court formally appointed Carol as executor. The supposed second will was never found, and a forensic document examiner Carol's probate attorney brought in testified that there was no record it had ever been drafted by the same attorney who prepared the real will, which told its own story about when and why Russell had invented it. He was ordered to repay the full $61,000 to the estate on a structured plan, and the court referred his sworn declaration about that will to the prosecutor's office to look at for perjury and theft. That didn't guarantee charges. It just meant it wasn't simply a family matter anymore. Carol met with Hetty not long after, apologized on her mother's behalf and her own, and signed an actual written lease this time, properly drafted, with the rent set at $375 a month. Hetty agreed without any argument because it was fair, and because somebody with the actual legal right to ask had asked her honestly. "Your mother would want it this way," she told Carol. And Carol, who'd never met this woman before that week, found herself standing in a stranger's living room, fighting back tears, surrounded by 22 years of somebody else's life that had almost been taken away by a man who never had the right to take it. "I didn't take that case for the money. There wasn't much of it. Hetty paid what she could, and I quietly wrote off the rest, because some cases are just the cost of being able to look at yourself in the mirror." What stuck with me afterward wasn't the hearing, or the dismissal, or even the look on Russell's face when that silence finally broke. It was the coffee can. 22 years of trust kept in a coffee can on a kitchen counter, because two women decided decades ago that paperwork mattered less than their word. It worked right up until one of them died, and the world that filled in around the survivor was full of people who didn't see the absence of a signed lease as decency. They saw it as an opening. Priya told me afterward, I'd just gotten lucky there was a sister out in Tucson who had no idea what her brother was doing. I told her that wasn't luck. I checked the title. That's the first thing anybody should do before they accept that somebody has the authority they're claiming to have. Most people never check. That's the whole problem. Somebody tells you they're the landlord, and you believe them, because why wouldn't you? If you take one thing away from Hetty's story, take this. Somebody telling you they're your landlord is not the same as proving it. Before you sign a new lease, agree to a rent increase, or accept an eviction notice as valid, you have the right to ask, and in most states, the right to demand in writing, proof of who actually owns the property and who has the legal authority to act for them. County recorder and auditor offices almost everywhere keep ownership records open to the public, often searchable online in a matter of minutes. And if the owner has passed away, that property doesn't automatically belong to whoever shows up to collect the rent. It belongs to the estate until a court appoints somebody with the actual legal authority to manage it. Until that happens, no arrangement, no matter how confidently somebody presents it, carries any legal weight at all. It takes about 5 minutes to look up a deed. For Hetty Doyle, those 5 minutes were the difference between losing a home and keeping one.